Greetings. Welcome back to IBI India Business Insights. In this video, we'll be looking at intellectual property rights in India. The World Intellectual Property Organization defines intellectual property as creations of the mind. They may be inventions, literary and artistic works, designs and symbols, names and images that are used in commerce. Intellectual property rights can be defined as the exclusive rights given to people and protected by law over the creation of their minds for a certain period of time. Intellectual property rights strikes the right balance between the interest of the innovators and the larger public interest in a way fostering the innovative spirit and making the innovation useful for the society. Generally, a property is of three types. First, movable, such as cars and furniture. Second, immovable, such as land and buildings. Third, intellectual, such as books and inventions. The various types of intellectual property rights are patent, design, trademark, geographical indication, copyright, semiconductor integrated circuit layout design, industrial design, and trade circuit. A patent is granted for an invention, a new product or process involving a novel step and capable in a commercial application. It is given for 20 years. India followed a process patent regime for a long period before turning to a product patent system for food, chemicals and pharmaceuticals. The Patents Act 1970 was last amended in 2005. The concerned ministry for patents is the Department for Promotion of Industry and Internal Trade. All the issues related to patents are under the office of the Controller General of Patents, Design and Trademarks. A design IPR refers to the features of shape, pattern, ornamentation, configuration, the composition of color or line applied to any article, 2 or 3 dimensional or in both forms. The Act which guides the office bearers regarding this is the Designs Act 2000. The concerned ministry for designs is the Department for Promotion of Industry and Internal Trade. All the issues related to design are under the office of the Controller General of Patents, Design and Trademarks. A trademark is a unique mark represented graphically and which can distinguish the goods or services of one producer from those of other producers. Its type are shape of goods, graphic representation or packaging or sound, sign, drawing, pictures, emblem, words, letters, numbers, colors or combination of colors. The Act which guides the office bearers regarding this is the Trademarks Act 1999, which was last amended in 2010. The concerned ministry for trademark is the Department for Promotion of Industry and Internal Trade. All the issues related to trademark are under the office of the Controller General of Patents, Design and Trademarks. Geographical indications mean any indications which identify the goods as originating in a particular territory, unique due to its climate, soil and native efforts. They can be agricultural, natural or manufactured goods. The Act which guides the office bearers regarding this is the Geographical Indications of Goods Act 1999. It is given for a period of 10 years in India. The concerned ministry for geographical indications is the Department for Promotion of Industry and Internal Trade. All the issues related to geographical indications are under the office of Controller General of Patents, Designs and Trademarks. The people who create literary, dramatic, musical and artistic works, producers of films and producers of sound recordings are given copyright by the law. It includes the rights to reproduce, adapt and translate a work. The Act which guides the office bearers regarding this is the Copyright Act 1957 revised in 2012 to conform to WIPO treaties on the Internet. The concerned ministry for this is the Department for Promotion of Industry and Internal Trade. All the issues related to copyright are under the office of the Registrar of Copyrights. They are given for innovation in integrated circuit layout designs. The concerned Ministry for Semiconductor Integrated Circuits Layout Design is the Department for Promotion of Industry and Internal Trade. All the issues related to this are under the Office of Semiconductor Integrated Circuits Layout Design Registry. The Act which guides the office bearers regarding this is the Semiconductor Integrated Circuits Layout Design Act 2000. The industrial design is an intellectual property right that protects the design or shape, color pattern, number of lines, 2D or 3D design of the object. A trade secret is a formula, practice, process, design, instrument or pattern which is not generally known, by which a business can obtain an economic advantage over competitors or customers. India is a member of the World Trade Organization and abides by the Agreement on Trade-related Aspects of Intellectual Property. India is a signatory to the following WIPO-administered international treaties and conventions relating to IPRs. Budapest Treaty, which deals with the international recognition of the deposit of microorganisms for the purpose of patent procedure. Paris Convention, the protection of industrial property. Berne Convention, working in the field of protection of literary and artistic works. Patent Cooperation Treaty. Protocol relating to the Madrid Agreement, the international registration of Marks Madrid Protocol. Washington Treaty, for intellectual property in respect of integrated circuits. Nairobi Treaty, the protection of the Olympic symbol. Marrakesh Treaty, which facilitates access to the published work to visually impaired people and persons with print disabilities. In 2019, the Union Cabinet approved the proposal for accession to India to the Nice, Vienna and Locarno Agreements related to the World Intellectual Property Organization's International Classification System. Now, let's have a look at the importance of intellectual property rights. Protection of innovation spirit. It safeguards the hard-earned intellectual property of an innovator. By protecting the legal rights of the true innovator, the IPR regime encourages innovation and creative excellence in the country. Economic growth. The knowledge economy is the catalyst of the nation. Driven under the robust IPR regime, the creative capabilities and innovation of the human resource can catapult economic growth to newer heights. IPRs help creators and inventors to realize their potential for generating and utilizing a product of their unique ideas, which would contribute to new business opportunities, employment generation, and in the end, wealth creation. Investment in research and development. The transparent and strong IPR regime encourages investment in research and development. IPR protection assures the organizations to work toward innovative products. India is in the need of newer and disruptive technologies in all areas including agriculture, water management, food processing, urban issues, military, space technology, etc. Balance between individual or organizational zeal and societal benefits. Inclusion of compulsory licensing and negating evergreening of licenses. India is a big market and leader in the generic pharma sector. IPRs synergize the strengths of the government, R&D organizations, educational institutions, MSMEs, and startups in the creation of an innovation-conducive environment for the overall economic development. Now, let's discuss some of the problems that are faced with intellectual property rights. Legal issues. Section 3D of the Indian Patent Act 1970 disallows patents to new forms of a known substance without any therapeutic effects. Compulsory licensing. Concerns are raised by the foreign investors who bring technology as they fear the misuse of CL to replicate their products. It has been impacting India-EU FTA negotiations. Problems with international standards. We continue to remain on the priority watch list of United States trade representatives for alleged violations of intellectual property rights. In Consecutive Special 301, reports released by the United States Trade Representative, the concerns have been raised about the IPR regime with respect to enforcement and protection of the IPs. According to foreign companies and investors, India does not care about the commercial use of test data or other data submitted to the government during the application for market approval of pharmaceutical and agrochemical products. Enforcement of the Copyright Act. The enforcement regime is weak and the piracy of copyrighted materials is widespread. The least priority is given to the adjudication of IP matters. The main challenge is to train and sensitize the enforcement officials to take up IP matters on the same footing as with other economic offences. Lack of deliberative platforms. No established platforms to bring the stakeholders to a common platform for discussion or for well-informed policy decisions in accordance with India's need. Now, let's look at some of the landmark judgments in the history of IPR, intellectual property rights. Bajaj Auto Limited versus TVS Motor Company Limited. This IPR case is related to a dispute over the patent for the usage of a twin spark plug engine technology. The Supreme Court of India, in this one of the landmark judgments on IPR law in India, has directed all the Indian courts for the speedy trial and disposal of intellectual property related case laws in the courts of India. In this case, a 2-year-old dispute involved two big companies which were locked in a patent dispute over the usage of a twin spark plug engine technology. The Supreme Court of India observed that the case laws relating to the matters of trademarks, patents and copyrights that are pending for several years and litigations are mainly fought between the parties about the temporary injunction. The Supreme Court has directed that the hearing in the matters of intellectual property in India should proceed on a day-to-day basis, and the final judgment related to a case should be given generally within 4 months from the date on which the suit was filed. The Supreme Court further directed all the tribunals and courts in the territory of the country to carry out the orders faithfully and punctually as mentioned above. Let us have a look at this another landmark judgment, Yahoo Incorporation versus Akash Arora and another. This is one of the first landmark judgments on IPR law in India that is related to the protection of intellectual property rights on the internet. The Delhi High Court in this case, which is known to date as one of the landmark judgments on IPR law related to cybersquatting, held that the domain name of a product serves the same function as a trademark, and hence a domain name is entitled to equal protection. In this case, the domain name of the plaintiff, Yahoo, and the domain name of the defendant, Yahoo India, were nearly phonetically similar and identical. In such a case, there is a very strong possibility that the users of the internet using the domain name of the plaintiff will get confused and deceived into believing that both the domain names of the defendant and the plaintiff have some common source or connection. The Delhi High Court also observed in this case that the disclaimer used by the defendants was not sufficient because the internet nature is such that the use of a familiar or identical domain name cannot be remedied by a disclaimer, and that also it did not matter that the domain name Yahoo is a dictionary word. The Bombay High Court in the case of Rediff Communication versus Cyberbooth and another also observed that the importance and value of a domain name are a corporate advantage to a company. Now, let us look at another landmark judgment, Novartis versus Union of India. The case is related to the rejection of a patent for a drug that was not inventive or had any superior efficacy. The company Novartis filed a registration of patent application for one of its drugs called Glivec by covering the drug under the word invention mentioned and provided under Section 3 of the Patent Act 1970. The Supreme Court of India rejected the application of Novartis after a period of 7 years long battle. The reasons cited by the Supreme Court of India were: there was no invention of any new drug. A mere discovery of an already existing drug will not amount to an invention under the Patent Act 1970. Under the Patent Act 1970, for the grant of pharmaceutical patents in India, apart from proving the traditional test of inventive step, novelty, and application, there is a new test of improved therapeutic efficacy for the claims that covers some incremental changes to already existing drugs, which the Novartis drug also did not qualify. This case became one of the landmark judgments on IPR law in India because the Supreme Court looked beyond the procedures and into the fact that the attempt of all such companies to evergreen their respective patents and make them unreachable at some nominal rates. The invention, innovation, and creativity are a lot like a lighthouse. It is like a public good that can be identified by two distinct characteristics, non-rival and non-excludable. It is a non-rival in the sense that the fact that I am looking at the lighthouse, it is not interfering with the ability of any other person to look at the lighthouse. It is non-excludable in the sense that it would be very difficult to prevent other people from looking at the lighthouse. Intellectual property is very similar to this. If I'm watching a TV show, then it doesn't mean that any other person cannot watch that TV show. If I've put an idea and turned it into an invention, I would not be able to stop others from telling that idea to more and more people. This is when intellectual property rights come into play. They turn a non-rival and non-excludable good into a rival and excludable good and thereby creating economic incentives. Once the legal right is exercised, then we can get paid for every time a person watches our content and we can exclude others from recreating the same content. Thank you for watching. Do subscribe to India Business Insights and stay tuned to more such videos. If you like this video, let us know in the comment section below.